as I, at the very least, adumbrated in the last little discussion, bankruptcy. If you can't get the creditors on board, well, you can try further negotiations. Maybe you can convince them of the wisdom of accepting a modified proposal. But if the creditor is just adamant that it's not going to accept what you're proposing, then you have to think in terms of bankruptcy, because there you have the power of the United States federal government to step in and, at least in some circumstances, force the creditors to accept what you're proposing. So sometimes that can be a good negotiation tool when you're in the pre-bankruptcy setting, and I have used that in negotiations, usually in this form. Look, my client is a good candidate for Chapter 7 bankruptcy. If my client files that Chapter 7 bankruptcy case, you'll get nothing. Wouldn't it be better to get a little something? If you work with us and we propose to pay you something, you'll be better off than if you maintain this adamantine mindset and you just refuse. I'm not going to negotiate. Great, you're going to get zero. So if the creditor still doesn't go along with it, then just go ahead and file a bankruptcy. Now, you don't want to make that kind of a threat if it isn't true. Because if you make that kind of a threat and it turns out that it's not true, and the creditor does a little investigation and finds out you're not a good candidate for Chapter 7, then all negotiations after that are over because you have destroyed your credibility. And as an attorney, I see credibility as perhaps one of my best assets. So I never lie to a creditor. I will obviously try to put forward the facts in the way most favorable to my client, but I'll never lie to a creditor. I'll never lie to a trustee. I'll never lie to a judge, because if I were to do that even once, my credibility would be shot.